Welcome to Occupations, the podcast, where we discuss what it's like to hold specific jobs. Occupations is brought to you by lotsofmaps.com, where you fulfill your vintage map gifting needs. Visit lotsofmaps.com.
Hi, and welcome to Occupations, the podcast. I'm Andy Jagalenzer. Welcome. We have a great guest for you today. His name is Craig Buschmann. He is the principal IP Counsel for Rio Tinto. And what does that mean? He's a patent lawyer, pretty much. And he's going to tell us all about patent law and how he got into his position. Welcome, Craig.
Thanks. Happy to be here.
Craig, tell me a little bit about the principal IP Counsel and what is it that you do in a nutshell?
So my job within the company is to help protect the company's intellectual property, their patents, their trademarks, their copyrights, and secure their competitive advantage for research and the things that they do better. And it sounds really fancy, and we obtain a patent. And so quickly, a patent is just a right to exclude others from practicing what is your property. So it really is, we can discuss this a little bit later. Yeah. It's really a lottery ticket to a lawsuit. It gets you a chance to enforce it. But if you don't even have that lottery ticket, you don't even have that chance. Anybody can copy whatever it is that you're doing. And then all of that money and time and resources used for innovation, someone is essentially just drafting on your coattails there.
Yeah. And IP, I know, stands for intellectual property, but tell me a little bit about what that is. I know that you sort of gave an idea of that, but to go a little further.
Intellectual property is an umbrella term. It covers your patents. So as I mentioned, if you have an invention or a design that is unique, you get an exclusive right for a limited period of time. It's essentially a government-sanctioned monopoly. So you have to file for that right with the patent office. There's also trademarks, protect the consumer impression. It's an association of a logo, a symbol, a sound, colors with a specific product. And that's important. It's tied to a specific thing. So, of course, some of the big ones that everyone is familiar with, Coca-Cola, Apple for computers, and so forth. Viagra, those are all trademarks, and they protect what's called the consumer impression. Mm-hmm. Then you have copyright. Copyright is the recorded expression of an idea. So it could be written things like books, memoirs, the note you scribbled on your Post-it note. All of that is copyright. Sound recordings, any sort of expression that is recorded down. And it has to be the artistic aspect. You can't protect facts. The last part of it is trade secrets. And so trade secrets, the legal thing is it's something that provides an economic advantage by virtue of it being secret. So it could literally be anything. Think of the formula for Coca-Cola, Kentucky Fried Chicken, Colonel Sanders, 8 Secret Herbs and Spices. Those are the things that are considered trade secret. If somebody comes up independently without knowledge of it, they can use your trade secret. It's like you're out of luck, but there's several things you have to do to protect it. And nice thing about trade secrets, though, is the protection is potentially infinite. So long as you keep protecting it and it doesn't leak and no one can reverse engineer it, you could have that kind of protection for a long time.
That's great. Well, thank you for that rundown. That's fascinating to understand that. And anyone who's creative, who has thought they've come up with a new idea like me every 5 minutes, this is for you. This is exactly for you. And I'm excited to get involved with it. Now, you work for Rio Tinto. They've asked that you make a statement just to verify that it's not their words that are coming out of your mouth. It's all you. And our goal is really to make this about you and not necessarily your employer, but just to protect you. If you want to go ahead and give that, that's great.
So I'm just speaking on behalf of myself in a personal capacity today. Anything I say today does not represent the position of Rio Tinto or any of its affiliates. And that pretty much covers it. So
great. All right. A little law in the law interview. I like it.
Yes.
I like it. All right, let's kind of roll it back and find out a little bit about Craig. Well, where were you born? Where'd you grow up?
I'm a Midwest guy. I am originally from Wisconsin, as you can probably tell by the way I say Wisconsin. And I went to high school. I grew up whole life there. And once I graduated, I left as fast as I could.
Okay, that's great. So let's start really young. When did you first get a sense that law might be something that you might want to pursue or something that you feel like you might have been good at? Was it at a young age?
I have a recollection that, relatives and things would say like, oh, you'd be a very good lawyer just because of perhaps I was argumentative or very precise. But I really didn't consider it until I got to college, my last semester in college.
Got it.
I was very more engineering focused as a kid. I was very good at math and science and put together models and tinkering with stuff. And that was the path I took initially before I got into the law.
And it sounds like you could have used a patent lawyer yourself with all the tinkering and stuff you probably did.
I don't know if I ever came up with any good ideas.
Okay.
It was mostly disassembling things.
Got it. Okay. What did you imagine you were going to be at that point?
What I really wanted to do, to be honest, was to become a fighter pilot. But I had poor eyesight and poor lungs, childhood asthma and some stuff.
Yeah.
And so when I graduated high school in 93, Cold War just ended. Everybody's military's riffing reduction in forces. And that combination of things, I was like, well, this isn't going to work, especially the eyesight thing. Maybe I can become an engineer and go work for, say, a defense contractor and still get to play with really cool things like airplanes and stuff.
Sure.
That was the kind of the idea graduating high school and starting college.
Had you flown before? Were you taking lessons or anything like that?
I hadn't taken lessons, but I had gotten enough rides. We had a neighbor who had his private pilot's license. He would take me up in his plane when I'd, help him work on his plane, help him fix his cars, babysit for his daughter and stuff like that. So I had a number of private flights in a Cessna before. Of course, watching Top Gun and all of those things, I was like, yeah, this is what I really want to do.
It's always about the movies, right? They romanticize things for us, and it makes us want to become them. So high school, you get through, you're leaning towards engineering, you finish, and you head towards what school?
I went to the University of Michigan in Ann Arbor.
Did you declare a major early on?
I did. I was accepted into the engineering program directly at the University of Michigan.
Wow.
And my goal originally was I was going to just do aeronautical engineering. But then again, with the whole end of the Cold War stuff, I was like, well, I should probably hedge my bets. And I was going to double major mechanical engineering and aeronautical engineering, which sounds super impressive. But the reality is there is a lot of overlap in all of those classes.
Yeah.
So they only diverge really quite towards the end where you have to take a couple specialized aero engine classes, wind tunnels, and really advanced mathematics and fluid dynamics and things like that. It wouldn't have been too hard.
Sure.
But then I decided after taking the advanced engineering math, which was a requirement for aero engineering, and everybody did miserably in that class. I do remember the exam. We all came out just looking shell-shocked. And I think the average was like 40%. And so it's curved, Michigan and in the engineering program, the curve is set at like a C+,
okay,
B- area. So it's not this soft curve or anything. It's a pretty hard one. So that 40% was, like a C+. And I was just like, oh, Laplace transforms, Lagrange equations and all of that is like, this is too much. I can get to 98% of what I want to do with just a mechanical engineering degree.
Got it.
And so at that point, I was like, this is fine. I can actually still go do and work on planes if I want to,
Sure.
with just a mechanical engineering degree.
Wow. Wow. Well, and I guess they're looking for the best of the best.
It wasn't me.
Well, yeah, but it also forced you to make a decision in life, right?
Mhm.
Instead of rolling the dice on one, and you got your 98% on the other end. So that's great. So what were you doing in school? Did you get any hands-on other than the college itself? Were there internships, or were there studies and labs and things like that were really teaching you some hands-on stuff?
Yeah, so I did 2 internships or 2 summers with a company called Johnson Controls.
Hmm.
Some of your listeners might be familiar if they see it on their thermostat. They do a lot with HVAC, heating, ventilation, air conditioning,
Hmm.
cooling, and fancy control systems about that. But they're also one of the largest automotive suppliers.
Hmm.
And so I worked with their seating division in Plymouth, Michigan, and we were making seats for, big automakers, Ford, Honda, Toyota, and so forth like that. So we did a lot of testing both on the products coming directly off the manufacturing line
Hmm.
and various new products. So that was kind of fun. You got to do some destructive testing to meet federal regulations. You have to pull these seats apart with the force equivalent to 20 Gs. So if a
Wow.
seat weighs like 100 pounds, you pull it with a force of like 1,800, 2,000 pounds and see what breaks. And it's not
Wow.
supposed to break at that level,
Wow.
at least not in any way that would result in a passenger being hurt. It's
Sure.
kind of have to have enough sufficient structural integrity at that force load so that a passenger will survive.
Wow. Did you have test dummies and things like that? Was that the kind of stuff you were doing?
I didn't get to do the test dummy stuff. These were just hydraulic cylinders pulling. They would do the test dummies on the full sleds,
Yeah.
but they didn't do a lot of them because it was about $1 million per test
Holy
back
cow.
in 1990 or 94-ish, 95-ish. At least that was the figure that I was told.
Wow.
It was just very expensive in terms of time, specialized equipment,
Hmm.
all of the data acquisition, the high-speed cameras, and so forth.
Yeah.
So it was a necessary part that had to be done, but they didn't do a lot of those, and it didn't overlap with my time there.
Sure. Okay. That's pretty cool. So you got your internship, you got a little hands-on, you had a little fun, sounds like too.
I also did 1 summer at GE Medical Systems in Waukesha, Wisconsin.
Hmm.
It was called the SCAT line, Systems Calibration and Testing. So
Mhm.
this was on X-ray systems. Once it's been manufactured, at the time at least, it was all still a very bespoke calibration process. This was just a little bit before everything started going digital. They're still hand blowing X-ray tubes.
Mhm.
Every X-ray tube is going to be just slightly different, regardless of the fact that these glass blowers are literal artisans. And so then you have to make sure everything's calibrated and tested appropriately before being sent out to the field.
All of this sounds great. I can see how you probably took all of this that you learned, all this engineering, and it probably helps you do the job that you're doing today, even though it's really has, I don't want to say nothing to do with it, but it certainly is not part of your job, the actual engineering itself. I can totally see how learning this was an important part of what you ended up doing.
It absolutely is. I kind of think of myself as a little bit of a translator, translating the engineering into the legal realm and being able to speak both languages
Hmm.
is really a way to think about what a patent attorney does.
Sure.
And there's no requirement you actually have to have had worked as an engineer
I
to
was going
become
to
a patent
say,
attorney.
yeah, I was going to ask that question. How, is that a common theme with patent attorneys?
A lot of patent attorneys just get their engineering or science degree and
Hmm.
then go straight to law school. I'm sure a lot of them are excellent attorneys, excellent engineers, and do a very good job.
Hmm.
My personal opinion is there's definitely an advantage to have had some actual practical work experience where you've gotten your hands dirty doing the things, the reports, the breaking stuff, the actual engineering aspect, so that when you are doing the attorney work, down the road, you have that much more facility with the engineering side of things. And you can ask the questions of the engineers, really dig deeper into their motivations, how they're doing something, so that you can recognize what might be the patentable or something unique and new and unknown that an engineer might just think, oh, I do this stuff every day. This is a normal Tuesday in my office.
Right.
I do X, Y, and Z. And it really may not be.
Got it. Well, it certainly doesn't hurt, that's for sure. But I can see how that would probably make it a little easier to understand. And like you said, to be able to speak that language so that it's not just, oh, okay, they're just doing something I don't know anything about. So, So you finish your schooling at University of Michigan. What's your next step?
After going through all of that engineering, I was like, well, I don't want to do engineering where you're just designing stuff. I like a little bit more of the hands-on, and had a couple of job offers. And I ultimately selected one with a company called Schlumberger. They're a large oil field services provider. They do a lot of the technology, and they're hired by the oil companies when they're out drilling wells and stuff.
Sure.
And so I worked as a field engineer, and I worked my first year in Bolivia, working on land rigs.
Wow.
And then I spent the next 3 years in the Gulf of Mexico, primarily. I was living in Louisiana, Lafayette, Louisiana, and working offshore in the Gulf of Mexico.
Wow. So what were you doing, literally? What was your job there on a rig? Were you covered in oil?
No. Well, typically not. No, it's obviously bad if that's happening. No, the glib answer is I was babysitting a computer. The longer, more accurate answer is I was called drilling services engineer. I worked with specialized tools, and I'm going to just, a little background is, so when you're drilling a well, you have the drill bit at the end of the string, and it's connected to the surface by potentially tens of thousands of feet of pipe. You have some vague idea of what you're actually going to be drilling, but you don't know in advance. It's because it's hidden by thousands of miles. You can do some studies in advance, but you don't know. So we put these special tools in that string of drill pipe close to the drill bit, and we can take measurements as the well is actually being drilled, send that data up to the surface, and so you can see first, where is that drill bit below you, and it might be a couple miles away from your surface location. It's really important to know where your drill bit is, because you want to make sure that drill bit goes into the reservoir you're aiming for. And you can steer that now.
Wow.
And then you're also getting actual geological data in near real time. I mean, we call it real time, and it's effectively real time. There's a delay of 30 seconds or something.
Wow.
But from that, you can see what is the actual type of rock. Is it shale? Is it a reservoir rock like sandstone or limestone? Is there water in the pore spaces, which isn't terribly helpful? Or is it an oil or gas in those pore spaces, which is what you're really looking for? Other tools, you can actually distinguish between whether it's oil or gas. And so in real time, you can say, like, are we getting all of this information? Is it what we're expecting? And if you find something great, then you can, complete the well, do all of the things to actually bring it online for production. Or you find out you've just spent $30 billion to drill a water well in the middle of the ocean.
Wow.
And you're like, well, we're done here. Let's go on to the next project.
Wow. So you were going through some of the numbers, or you were just making sure that the numbers were reading properly?
Yeah, so we had our tools. We set up and programmed the tools, make sure they're integrated with the rig operations. And in real time, we're acquiring that data, generating what are called logs, which is just fancy graphs, and analyzing and finalizing that information to then give to the client, the oil company.
Got it. Okay. 4 years of doing that, that's a lot. And especially the last 3 years in the sea, in the Gulf of Mexico, hot as can be, I imagine, down there. And Lafayette is probably pretty hot too, but
yes.
kind of a cool area. Was it time to move on, or what was going through your head at that point as far as your future?
Yeah, so as I joke to everyone, it's like after you spend 3 years on a steel deck in 100 degrees and 100% humidity
Mm.
in the Gulf of Mexico, even law school seems like a good idea at that point. um, I kind of achieved a bit of mastery at the level I was at, and I really had hoped to go back overseas. Had I gotten the chance to go back overseas with Schlumberger, maybe I would have still been doing this.
Mm-hmm.
A tricky part of it is I had kind of made myself too valuable to one of our clients, or at least that's my impression, because I'd been working with these clients on these very high-profile deep water projects for 2 years and had a very good rapport with them. It was going to be very difficult to get out of that situation soon. And so I was kind of bored with what I'd been doing. That client had actually approached me about potentially working with them, and the timing just didn't work out. And so I was like, well, I better study for the LSAT exam that's coming up in a week. So I didn't prep a whole lot for the LSAT.
Okay.
Because I thought I might end up working with this client, and that just didn't come to pass.
Wow. All right. Well, that just shows your law capabilities and knowing that you didn't prep and you still passed, I assume.
I did well enough. I certainly could have done better, but yeah, I was happy with how that turned out.
That's great. Okay. So law school, where'd you go to law school?
I went to Boston University, and of course, Boston, and their law school program, and I started that in 2002.
Long way from Wisconsin, Michigan, and Lafayette, and Bolivia.
Yes. Yes, indeed.
That's good. So you come to the East Coast. BU offered a good program. I imagine that their law school is pretty good.
It is pretty good. The East Coast in Boston, I was interested in living there. And I was fortunate with my job with Schlumberger that I could get away and had the resources. I could actually visit a number of the schools that I applied to. And the reason I ended up going to Boston University is I didn't schedule visits. I just kind of showed up and said, hey, I'm here. I'm just kind of walked around trying to just gauge the vibe, because I didn't want the sales pitch, if you will.
Yeah, sure.
I dropped into Boston University, their law school, and their student council office is right there in the foyer, or at least it was in the early 2000s. Poked my head in, introduced myself, and just a bunch of very outgoing, friendly people there. And it immediately just felt like, oh, this is kind of the place that I would like to go.
Huh. That's great. Kind of did it yourself, and that's good. I like that. Did they specialize in any type of law, or is it general law that they work on?
Broadly, it's general law, but it's been a minute since I've looked. But they are known, or at least were certainly known for their intellectual property, which actually wasn't necessarily my focus at the time. But they had some very prominent copyright attorneys and patent law attorneys teaching at the school. They did a lot with like health law and financial business regulatory law as well, at least at that time. And it's probably changed in 20 years.
Sure. So what was your focus going in there?
I thought it would probably be patents, but with the international aspect, I also considered maybe doing something related to international law. I hadn't decided. A reason I had been thinking potentially patents is in my last semester at undergrad at the University of Michigan, I took a course called Intellectual Property Law for Engineers. And the professor, she was an engineering professor, and she just got her law degree and put together this elective. And she taught the class just like a law school class. Socratic method, same case law book. We covered patents, trademarks, and copyrights. And so I found it actually really interesting. So that was kind of where the idea was planted, is in undergrad with this elective. So that's sort of where I was thinking when I went to law school. I have the engineering background. Going to law school, it seems like a natural fit.
Yep.
But I didn't have to decide at that point.
Sure. So you weren't sick of engineering in any way. Even though you turned to law, you still were happy enough with your knowledge of it that you wanted to continue to work in that field.
Yeah, exactly.
Okay. All right. That's good. So how many years did you end up doing at BU?
3 years.
3 years. Great. So were there internship opportunities for you at Boston University?
There were usually most students work during the summer in various positions. My first year after law school, I worked for a small real estate law firm in Newton. Massachusetts is unique, at least at the time. I don't know if it's still the case. They required an attorney to be present at closings, at house closings. So, like, you buy a house. So you had to have an attorney. And so I worked, and this was set up through the school's job placement program. I worked at this real estate firm, and I was doing what are called title opinions that summer. And a title opinion is just, is there a clean chain of title from whenever it was first acquired to when you're buying it? So it's just making sure that someone who's selling the property has the actual legitimate right to sell that property.
Right, right.
It was interesting. There were a couple cases as a commercial project that I did one on for like a cell phone tower, and they had to do the chain of title all the way back to the colony. And so there was like a written record, here's the land grant from the king and so forth.
Wow.
But most real estate deals by statute, you only have to go back like 50 to 100 years at this point.
So do you think that king had an idea that there was going to be a cell tower on his land?
Probably not.
Wow, that's crazy. Love that. All right. And so that was your first year, summer of your first year. What else did you do second year?
They would do these patent-specific job fairs for law students at a central location. And so it was late summer after my first year of law school. This one was in Chicago. And so students would fly in or drive in, all these law firms, and you would just do back-to-back interviews. So I had, I think, 7 interviews over 2 days with 7 different firms. A friend in law school who had an electrical engineering degree, which is and still is a very high demand for patent attorneys. He had somewhere on the order of like 20 or 25.
Oh,
so
holy
yeah,
cow.
it is just, imagine your brain melting after that many interviews in literal hotel rooms. You're just sitting there. There's the 2 beds, 2 partners in the suits. You're in a suit around this little hotel room table.
Wow, 25. That's not 7 is a lot. I can't imagine that. Wow.
Yeah.
That's crazy. Okay, so you ended up coming out with something, I assume?
Yeah, so I got an internship for my second year at a law firm in Salt Lake City, a small patent boutique, which means, well, it was an intellectual property boutique, but it's primarily patents, and that is the only type of law they practice. There's big general practice firms that will do kind of everything, sort of the big box store version of a law firm. So whatever your specific type of law, they'll probably do it. Intellectual property, because of its somewhat unique nature, it tends to have a lot more boutique firms where that is only what they practice. And so I got this internship out here in Salt Lake and moved out here for the summer.
All right. And obviously you ended up being there in the end, but was that just coincidence or did you fall in love with Utah?
It was twofold. I really enjoyed the outdoors stuff out here. And when I was looking for job positions doing patent law, the fact is I kind of was looking for something with good skiing first and the job second. And so
remember that, students. That's a very important thing, students. It's all about the skiing.
Yes, indeed. So it's like, and it was a fairly loose definition of good skiing. I wanted good skiing within at least a 3-hour drive. So Boston, certainly 3 hours. You get up into Vermont and Maine and New Hampshire and stuff. Whether you call that good skiing or not probably depends on whether you grew up on the East Coast or in the West. That was the sole reason Salt Lake City ended up on my job search, was for skiing.
Got it. All right. You got your priorities in order. That's good. Okay. So what was it that you were doing there?
Pretty beginner stuff. So for a patent attorney or a law student who is interning, you usually start out with what are called office actions. You have to file to the government for a patent right. You don't automatically get a patent right. unlike in a copyright, as soon as you write it down, you technically have a copyright in that. You have to apply to the patent office. And it goes to what's called a patent examiner. And that patent examiner, she will analyze what you're claiming is your invention. And she will determine whether somebody else has disclosed that idea.
Mm-hmm.
And the reason it's disclosed, not even like, does somebody else have a patent, is have they disclosed it? If it's known generally in the world, patent law doesn't want you to file for a patent and take something out of the market that is already out there and is known.
Got it.
So that's the idea. That's what we call novelty. Or would it be an obvious combination of two different things? So obviousness is this legal idea of, say you're combining two things together and you claim that you're using nails to hold these two things together. And maybe some other patent application shows the same thing, but they're using screws instead of nails. But then the examiner finds a different patent application that shows combining things with nails. And that patent examiner, she might say, hey, this first patent application shows everything except the use of nails. It shows all your components, but it uses a screw. But here's another application that shows using a screw to combine things. So one of skill in the art, a typical engineer, would be motivated to combine these two references because you're just using a different component to achieve the same function. And so therefore it's obvious. I kind of glibly describe this as a sort of like a well duh test, like well duh. It'd be, of course they would put these two things together. So again, the idea is the government wants, if they're going to grant you a monopoly, they want to make sure that it truly is something that advances technology. It's not just a little rearrangement.
Well, there goes my idea for using screws to hold things together.
So that's sort of the framework. And then as a second-year law student, what I was typically doing is someone will have prepared a patent application. The examiners looked at it and she said, no, this isn't patentable. I have to analyze that examiner's argument and either reply or rebut her argument and say, your argument doesn't make sense on these legal grounds or these factual grounds. Or if the examiner's made a good point, what we can do is narrow the claims. The claims are the operative part of a patent and is actually what you're claiming as your own.
Got it.
So we can maybe make that claim more narrower to get outside of, say, the screws and the nails and say, well, we wanted all of those, but we're only going to do a dovetail joint. So we're not even using nails anymore. It's a dovetail. It requires a special shape of the wood that you're combining together, tongue and groove, those sorts of things. So it's a narrower right for the patent applicant, my client who I'm representing, but it respects what else is out there in the examiner's position.
Got it. So yeah, so you're narrowing it down so the patent is all yours, all comes from
Correct.
Yeah, and even though someone might have had a similar idea, there's still maybe something in there that you can patent.
Exactly. So that's sort of the entry level aspect, is those arguments of those things. You don't start typically drafting it applications until you've graduated and passed the bar exam and the patent bar exam.
Okay. Well, I imagine that really kind of helped you in the job that you're doing now. That was really the start, right? Right there?
Yeah, it is.
All right. So what was the next step? You got your third year and you're getting close to finishing. What are your thoughts?
Yeah, at that point, I had gone down the patent path and it made sense. I was enjoying it. It was also somewhat practical in the sense that as a patent attorney, I can do litigation, particularly as it relates to patent laws and trademark laws, intellectual property laws. So I don't have to necessarily do patent applications and so forth. Just having that specialized background, even if I ultimately decided later on in my legal career that this wasn't for me, I could still go back and practice, say, criminal law or
Hmm.
divorce, family law, or business law, commercial law, things like that.
Sure.
It just provides a good background in a unique area as a foundation for other things if that's what I wanted to do.
And were you looking for job offers at that point towards the end of your third year, or were you just focusing on school and you'll figure that other part out later?
Yeah, so it's an interesting thing with law students in law school is your fall semester of your third year, your last year in law school, nearly all of the students are very much trying to nail down a job to have once they've graduated. And more often than not, it's that job you interned at in your 2L summer, your second summer
Hmm.
in law school. So that's sort of the natural place. It doesn't always work out that way, but that's the typical place many will go to, whether that's usually a law firm, but it might be a nonprofit, an NGO. Rarely is it directly into a business, although it depends. Some very large businesses that have very big legal departments
Hmm.
will take law students directly. In addition to your classes in your fall of your third year, your on-campus interviews like multiple times a week,
Hmm.
if you're lucky enough, and you could be flying off for second round interviews to all of these places and so forth. So it's a very packed period of time.
Yeah, I bet. So what were you doing? Were you visiting a whole bunch of companies, and what was your end of your third year like?
I was interviewing. I certainly liked Utah, but I wasn't convinced that the particular firm was the place I wanted to be at the time. It's a very good firm, but I wanted to also just test the water, see what else was out there. As it came about, that's ultimately where I ended up, was at the firm I did my 2L summer with out in Salt Lake City as my first job after graduation from law school. It decided, like, you know what, this is the right place. It's a good job. It's a good place to start. And the skiing and outdoor stuff for Utah certainly can't be beat.
There you go.
Lotsofmaps.com. Vintage, local, national, and world maps for an affordable price. 99% of our maps are $25 or less. Great as gifts. Frame them or put them under glass for your home, vacation home, or as a memory of a special place. Lotsofmaps.com.
So off you go. You're in the working world now, and you've joined this firm. So what were you exactly doing there for them?
So I was doing those office actions I discussed briefly
Yep.
before. Also, patent applications. So at that point, I started drafting patent applications. There may be some parts of the background that you can. So the background is part of a patent application. You describe what else is out there. What is this field of technology? Why is this thing new and great? But the rest of the patent application typically is bespoke in the sense that whatever you're describing is probably pretty new, and nobody else is going to have described it yet by virtue of it being new. So it's a lot of writing. A patent application, depending on the complexity, is typically between 20 to 100 pages. I would say 20 to 30 pages is fairly typical, but it's a lot of writing. And a lot of what you're doing the first 3 years, 4 years, is just developing a verbal toolbox of how to describe things. Because it's very complicated how you describe things going together. And the example I often use for this situation is explain to somebody how you would make a peanut butter and jelly sandwich. I mean, something we all know how to do, but how would you actually describe it? And so as a patent attorney, you might be like, well, you have a piece of bread. Well, what is bread? What is bread? You've got to describe the constituents. What is the bread made of? The geometric shape of the bread. It's typically rectangular. You have one side, and spaced apart from the first side is the second side. And in between those two sides is the actual matrix of the bread components. And you put peanut butter on the first side, and things like that. And it's not a normal way to talk.
Yeah, right. So even though you're not trying to get a patent for bread, you still need to explain bread because it's a part of what you're doing.
Right. So that's a good question because it provides context for the broadest thing you want to claim. But if in the process of the application, the examiner, she looks at it and says, well, I have a different patent application that shows someone putting cheese on a cracker.
Hmm.
It's got two sides, you've got
Right.
a filling, a cheese, you might replace with peanut butter. They're kind of similar in consistency. Well, all of a sudden it's like, well, how am I going to save this? I need to now describe, well, what is the bread?
What's
And
the
unless
difference
you've
between?
actually,
Yeah.
and unless you've actually disclosed that in the four corners of your application, as of the date you filed that application, you don't have that ability to narrow it. You can't add new
Ah,
things after the fact.
got it. So you want to name everything and pare it down if you need to.
Exactly.
Got it.
And that's where the experience of having the engineering background and if you've worked before in the field or just in engineering in general, you can go to that engineer or that scientist and say, well, you say it's this, but what is it made of? What's next? How might you do it differently? Because we want to try to capture all of that up front.
Got it. Well, that's good advice for me because I'm hoping to patent a peanut butter sandwich one of these days soon. So that's good to know. I know the guy to go to get a patent on that.
Exactly.
Awesome. All right. So you're doing that work. And what kind of materials are we talking about? What is it that you're patenting or at least examining?
When I was starting out, I represented at an oil field service company, a different one, not Schlumberger. So it did a lot with drill bits and the actual cutting elements for drill bits. So I already had a technical background in that. It was a natural fit. And
Right.
that was why this law firm hired me in the first place, because it was a very unique fit, technical background and experience. I also did a lot of semiconductor work. So the chips and how the chips are made that go into your phones, your computers, and things like that. And that was an interesting practice just because the semiconductor industry, computer industry, everybody has all of these patents, and it would be somewhat like a Mexican standoff if anybody tried to sue anybody. Like, we've got these patents, you're infringing, the other side's saying, well, we've got these patents. And so what they would do is they would have a patent pool, and they would just put these patents in a pool. Everybody pays a fee and gets rights to all of it. But the value you get for the licenses, so everybody pays in, you get a portion of those fees paid in out based on the number of patents you put in the pool.
Okay.
So there's an incentive to have as many patents as possible, at least in that industry. It doesn't matter if it's particularly unique, the patent application. You keep trying to get variations of it. So I described it as like, oh, well, this one is cornflower, this one is robin's egg blue, this one is sky, this one is a cerulean, just like every various shade of difference. You're trying to get an application just to have more patents. So just because of its sheer volume of that, and it's a very crowded field, it was a good experience in terms of just developing that toolbox of words on how to describe things.
That's interesting. Okay. So it was about sheer volume to not only save them money on fees, but also to kind of give into the future of things, I guess, right? You're helping out the future of things. And it provided you a job, which is the most important part.
Yes.
Wow, that's great. So how long were you doing that work?
So I worked there for just under 2 years at that specific firm. And I just wanted an experience where I could do some litigation in addition to doing patent applications and patent drafting, get more exposure to trademarks and some other things. So I changed firms to a different firm here in Salt Lake City that indicated there was the possibility of doing litigation in addition to the patent application stuff. And so I moved to that firm, and it actually worked out. I had to do a fair bit of litigation. It was at that firm I met my mentor. I worked with this senior partner for 6 years, and he was the one that really taught me a lot about just the law in general, how to run a practice, how to service clients, how to just do the job well.
Yeah, I mean, having a mentor probably changed everything, right?
Yeah, it definitely did change a lot. And also, just like I said, I was very happy to be able to do some patent litigation, trademark litigation, and so forth, because while you ideally should know both of those things, even if you're only practicing in one in terms of IP law, knowing litigation and how to attack and defend a patent or a trademark makes you a better attorney on the application side, because you've seen and sort of absorbed these different weaknesses and strengths and defenses and so forth. So you can incorporate that ahead of time when you're advising clients, drafting your patent application, and so forth.
Okay. Well, and, experience, right? It's all about experience and having knowledge in different areas, no matter what you're doing.
I've got another litigation story for you, a little war story.
Sure.
In terms of litigation, you often don't have like clear good guys and bad guys, especially when it's companies duking it out.
Sure.
But there was, this would have been about 2010, I represented a big tech company on a trademark infringement case. And these scammers were using their trademarks and telling people, like, with this company's ad, program and so forth, we'll teach you how to use it. Send us $10 and we'll teach you how to make money, $3,000, $4,000 a month with this company's, ad program, sort of thing. And it was just a big scam because, in the fine print, if they had it, it'd be the fine print would be like the same color as the text would be the same color as the background.
Sure.
So you couldn't actually read it, even though if it was technically there, or they didn't have it. And so these people oftentimes, a little bit more desperate, or maybe a stay-at-home mom who wants to make a little bit of money, would pay this and unknowingly agree to then their credit card being charged, tens to $100 a month for this service in perpetuity. And whatever quote unquote program they downloaded might be riddled with viruses to steal more information.
Oh boy.
So these scammers are making, millions of dollars. And so we sued them for trademark infringement because the big tech companies, like, these people think that we're involved with this because you're saying, do this company's ad program and make thousands a month.
Wow.
And we have nothing to do with this. And you're confusing them. The Federal Trade Commission and the state consumer protection bureaus typically don't actually go after scammers unless it becomes so big that they have to. So some of these scammers, they might be making $5, $6, $7 million a year. For a big agency like the FTC, that's not big enough for them.
Right.
And it's too big for a state consumer, or they just have resource to sue them themselves.
Got it.
So this tech company is like, well, we have to do it. And it's like, we shut down, I think, 6 or 8 of them. There was a number operating in Utah at the time. And, so that actually felt good. I was like, oh my God.
Yeah, that's good.
The most surprising thing is we had filed the lawsuit and national media picked up on it. And I don't know if it's like Good Morning America or one of those morning programs.
Wow.
For stay-at-home moms who might be susceptible to this sort of scam. They're talking about the lawsuit and the news footage, the graphic of like the complaint being fanned out on the thing, and it's like, there's my name right on national TV as
a hero.
The guy, the associate that's drafted it all for the most part. It was great. Like the second or third name on the complaint, because the partners, awesome. Of course, come first.
Right, of course. And how long were you there? Because I know you're not there now. What year is this?
When I moved to the second firm, this would have been late 2006, to 2011.
Okay.
2011 or 2012.
Okay. You're talking 5 years with your mentor, but you ended up making a change. Where did you go and what caused that thinking?
This is where you get into the law firm drama.
Uh-oh.
So the firm I was at was a regional firm, a fairly large regional firm in the West, something like 250 attorneys. And the Salt Lake office had very frequently been the most profitable office out of all of the offices, including the Denver office that had like 100 plus attorneys on a per partner basis. And even I think 1 year in just the sheer profitability. So you can imagine like how much more the partners in Salt Lake had to earn that year to out earn the Denver office that was 2.5 times larger.
Right.
So those partners were not happy with how the revenue was being split.
Oh boy.
With the big firm. So yeah, the Salt Lake City office literally said, we're moving our entire office to the arch rival across the street, another big general practice firm based in the West. And at that point, I was like, well, I could conceivably go, but the problem is I had just the year before landed a very large client. So it's a little atypical to have an associate at 6 years land a Fortune 100 client.
Wow.
And that client had a subject matter conflict with the rival firm. And what that means is they are working in the same technology areas. Lawyers have a duty to their clients. So it was very likely that in the patent application process, rival firms' clients' patents would be cited against my clients and vice versa.
Right.
And if you don't owe a duty to your client, how can you disparage one or the other's patent applications in the effort to try to get a patent for the other client, if that makes sense? I know it's getting a little recursive there, but
it sounds like you're, if it was criminal law, you're on the prosecution team, and then halfway through you decide to go over to the defense, right?
Yeah, exactly. And so for good reasons, ethics rules prevent lawyers from doing that and law firms from doing that. So there is no doubt or ambiguity. So I couldn't make that change. So I ended up going to, at the time, it was the largest, I think the largest or one of the largest patent boutiques in the country based in Chicago. But they had a small Salt Lake City office with 4 attorneys. And so I could keep my client, move the stuff there. And it wasn't my idea to make that change.
Yeah.
Things that were going really well where I was at, and then stuff happens in life.
Mutiny.
And you just have to adapt. Yeah, exactly. Have to adapt with that. So I didn't get to do litigation at the new firm that I had moved to, unfortunately, whereas I had been doing some a little bit. Litigation was probably about a third of my practice.
Were you enjoying the litigation?
I actually was. It's a lot of work. It's a little stressful, but it's there's a competitive aspect to it.
Sure.
If you have that personality, it can be kind of fun. I don't think I'd want to do it just litigation because it is intense, the time demands and so forth. But as part of it, I enjoyed trying to solve a problem, research on a short time frame, and then on occasion actually standing up in front of the judge and making an argument.
TV and movies certainly romanticize that, but the work that goes into it, I imagine, is, like you said, intense and long hours. Yes, indeed.
Just as an example of that, firm I was at with my mentor, we were in a patent lawsuit. And you have what's called in patent law a Markman hearing, and that's where the judge decides exactly what the claims mean. What is the property right at interest? Because it's put in words. There might be ambiguities in the words, how they're interpreted. The judge gets to decide. So it's a lot of work because in most patent cases, it turns on what the actual interpretation of those claims are. It might be the difference between a defendant infringing and not infringing.
Okay.
So it's a lot to prepare for. I argued part of our case. So the first time I was in front of a federal judge, argued part of that hearing myself. The mentor argued another part of it. Thought it went okay. Usually courts are slow, takes, several weeks to months to issue a decision. And the partner's like, great, this big bit of work is done. I've got a vacation planned. I'm going on safari to South Africa. I'll be back in, 3 weeks. Plenty of time.
Right.
And then shockingly, the judge entered a very unfavorable decision for us, 10 days, 10 calendar days, not even 10 business days
Wow.
after that oral hearing. And we're like, this is bad. The partner's in South Africa on safari. And so I was there by myself, essentially trying to figure out, like, well, how do we do this?
Wow.
And so that was to the litigation aspect, 14, 16-hour days trying to marshal. And there are provisions where you can petition and say, Your Honor, you really made a bad decision here. You messed up the facts and the law here. That's essentially what you're trying to argue. As you might imagine, judges don't often appreciate that.
I can't imagine that. Yeah.
So we file that, and then the partner, I was able to speak with the partner a bit, kind of walk through the various things we were doing, could share some of the stuff because technology and communications were available, but weren't quite as robust, especially to places like South Africa in 2008.
Wow. Okay.
So we get back, and the partner, my mentor, says, you know what, Craig, you should argue this motion that the judge really got it wrong the first time yourself. I think he really connected with you when you argued the motion in the first case. So it went poorly for me. So I actually have a bad decision in the federal case law reporter.
Oh, no.
I mean, it's just upholding the decision with more detail, but I'm in the reporter, the legal text where all the decisions are recorded with my name there on the motion. So it's just sort of funny.
On the wrong side.
The partner
of the motion.
Yeah.
Yeah. Well, yeah, you win some, you lose some, right?
Exactly.
Yeah.
Happy to say that we won the settlement, though. So,
all right.
Because the reality is most lawsuits actually settle. Very few actually go to trial just because the costs are too high all around, not just the judge or jury's decision on damages, the legal fees, and so forth. So most cases come to some sort of settlement before it even gets to that point. So,
well, that's good. That's one for the win column then. That's good. When you left that firm, were you no longer working with your mentor?
He kind of semi-retired. He went to another firm where he could just continue representing his smaller book of clients at that point, and then also spend about half of every day golfing. So
that's pretty good.
But I'm still in touch with him. But at this new firm, this Chicago-based firm that had the office in Salt Lake City, I was there for about 6 years, just doing patent applications. So both for my clients and some of the firm's clients that worked with the managing partner of the Salt Lake City office. So oil field work, big construction equipment manufacturers, industrial freezers, sporting goods. Being Utah, did a bit of sporting good and outdoor work, things like that.
So you finish up 6 years, and who comes a knocking?
Well, it was an attorney I used to work with way back at the firm I first started with in Salt Lake City. He was in Houston, and it was an opportunity to retain more of the money I generated from my own clients. And the idea was that being in a Houston-based firm, even though I was working in Salt Lake City, it might help get my foot in the door with oil field clients because, I have that technical background.
Right.
But the Texas legal market is very parochial. If you didn't go to law school with Bubba at Southwest College of Law, you're probably not going to get the work from them, right? No matter how skilled you are. They would give me an office footprint, a Texas phone number to kind of make that appearance of a Texas presence, even if I wasn't always there. I'd go a couple times a year for sure. But that was the idea because by the 2016, 2017, telecommunications were such that it really didn't matter where you were working. So I started working from home in 2017.
Okay.
So
that's good. How was Bubba to work with? Was he okay?
Well, the managing partner at the law firm down there really went sideways. And
Uh-oh.
yeah, it's unfortunate. I considered that person a friend at one point. Certainly don't now.
Oh, no. Was his name
Yeah, it
Bubba?
was, no, no.
Oh, okay.
um, if your listeners want to dig enough, I'm sure they can figure out who this person is. He's been in a bit of trouble with the law and various sanctions by many different courts
Hmm.
for his litigation practice. I did not do litigation with this attorney.
Yeah, okay.
I just, worked remotely from home, servicing my own clients.
Hmm.
What may be of interest is that, it was a difficult ethical position that I was put in. I ended up getting let go from that firm after trying to sort out some of these issues that were affecting my clients. And as attorneys, your role is to represent your clients and protect your clients. So long as your clients are doing the right thing, you might have to take the hit if that's what it takes to do right by your clients.
Right.
And so, yeah, I was let go from that job because I was standing up for my clients.
Hmm.
And it was certainly a stressful situation. My spouse had a very good job at that point. She was actually making a little bit more than I was. So it's like we could manage the storm for a little bit, but I was able to find another job fairly quickly. And if there is anything about karma or stuff like that, since that time, that managing partner at that firm has really gone off the rails, and federal judges have noticed, and he
Oh, boy.
is being held to account financially and potentially professionally
Hmm.
at this point.
Okay. So steer clear anyway. That sounds like it worked itself out in a good way in the end.
One of the things with the legal sector is it's a very personable, face-to-face, relationship-based business. I'd kept in touch with various attorneys that I'd worked with through time that I liked working with. And so I reached out to one of those attorneys that I had started at the same time he did at the very first firm here in Salt Lake City, way back in, second year of law school. We started together after we graduated, kept in touch with him, and I reached out and just said, hey, here's the situation. He worked with the managing partner of the firm he was at, and they were able to bring me on fairly quickly afterwards. So yeah, that's probably applicable to everybody. Don't burn any bridges on your way out,
Right.
and keep in touch with your coworkers and friends and colleagues sort of situation.
That's good advice. Great. And similar work, I assume?
Yeah, just patent applications
Mm-hmm.
for the most part, and some trademark work as well for different clients.
So you were there for how many years? 4 years?
A little bit less than 4 years.
Okay. And then finally, your current employer has an opportunity
Yes.
for you. How did that manifest itself?
It was very fortunate. It was just a LinkedIn job posting, and it was for Salt Lake City or Chicago, but primarily Salt Lake City. And I was like, oh man, my technical background and legal experience are a perfect fit for this. As a matter of practice, lawyers tend to keep their resumes fairly up to date. So I applied very quickly, and yeah, I was very fortunate to ultimately get the job here in Salt Lake with Rio.
Sounds like they were lucky to find you having that kind of experience.
Yeah, it was a good fit.
So are you doing the same kind of things there?
Yeah, so I'm doing similar work. So a lot more of what I do and most in-house patent attorneys do is we're more business advisors at this point.
Got it.
We do work with the scientists, the engineers, and the inventors. We might harvest their ideas. In a lot of companies, we will then send that out to a law firm, places like I used to work, and the law firm outside counsel would prepare the patent application, and they would manage the application process. They would keep us advised, ask us for our feedback and input and so forth. So we're typically the middleman between our engineers, the outside law firm, and helping the company make the best decision from a legal and technical point of view and business point of view, because there's obviously a cost benefit to all of this.
So tell me a little bit about what Rio Tinto does.
Rio Tinto is the second largest mining company in the world, and we mine things that we all use every day. So its biggest commodity is iron. About 60% of the revenue is generated by iron. So obviously, if you drive a car, you ride in a public transit on a bus or a subway or a train, fly in planes and so forth, anything that has iron involved with it or steel, it's there. We do copper mining, boron mining. So we have one of the largest boron mines in the world in California in Death Valley.
Hmm.
Boron might be familiar to your listeners with borax, borax soaps, but it's also used as a wood preservative, pesticides, fertilizers. It's used in glass, so Pyrex, borosilicate glass, semiconductors, and batteries, lithium batteries, and so forth. So it's a very important, if very small, part of a lot of different things.
Yep.
Titanium and lithium. Lithium is, of course, everybody has a lithium battery in their pocket with their cell phones, and aluminum.
You're doing mining. You started on an oil rig that was doing mining, really, just offshore kind of mining. You've certainly got your niche in law, and your expertise in a particular area has, I assume, helped keep you employed and helped to satisfy your bosses and your clients.
Yeah, absolutely. And I kind of fell into it. I certainly didn't grow up thinking I'd be in the extractive business in any sense whatsoever.
All right. So can you just give me a brief description of day to day, what you're doing? And I'm sure every day is a little different, but give me a little bit of an understanding of what it is that you do day to day.
Yeah. So a typical day might involve working with engineers. They might have a new idea, and I would be sitting down with them to discuss that idea and kind of what we would call an invention harvesting meeting. Kind of collect that idea and then be able to put it in a form to send to outside counsel to see if there's going to be a patent application that we file on that. As part of that process, we do what's called a novelty search. It's just a quick pass to see if something else is out there, some other business has a patent application that is right on point. Because if there is, we're not going to waste our time and money trying to patent something that somebody already else has disclosed.
Got it. So research, I assume, is part of the gig too, or are you passing that on to others?
Yeah, we have somebody else do that research, but then I will analyze the results of that research.
Got it.
There might be a lot of contract stuff, so probably at least half of my work is contract related. So say we're doing a research project with a university. So we've got to have an agreement in place governing how is that going to be managed, not just who's paying for what, but who owns the information, the data that comes out of it, any inventions that come out of it, the technology, how is it going to be disclosed? Universities have a public charter to share information, and we are supportive of sharing that information so long as it's not, our trade secrets or, commercially sensitive information. So there's a balance to that. So those sorts of agreements with vendors, sort of the same idea. We hire lots of companies to work with us. Who comes up with ideas, working together, who owns those ideas, sorting out those sorts of situations. So that's sort of the contractual aspect of it. And then occasionally there is, litigation support. We don't run the litigation internally. Outside counsel will run litigation, but we're the interface, the legal advisors to the business that can kind of translate outside counsel's position to the business people on the inside and help guide and the strategy behind those things. So that hasn't happened too often for me yet, but it certainly can. And then, I do a bit of trademark stuff and copyright things as they come up. So occasionally it doesn't happen often. I've been involved with helping do some internal compliance investigations, make sure everybody in the company is following the rules. And and so forth, because we do take that very seriously, ethics and compliance.
You're doing mining and extracting. That's probably some dangerous work.
It certainly is. And safety is a big consideration, not just for the actual people working in the mines,
Sure.
but as a culture. When I started, even though I'm a lawyer and I spend most of my time in an office or at home in my home office, I went through the same MSHA, Mining Safety Health Administration course that everybody who works in the actual mine went through. I have a mining license that I have to renew every year.
You can dig in your backyard anytime you want.
Yes, exactly. So it's a very serious thing. We start every meeting with a safety share. So again, even though we're the business people, we have to share sort of be aware of this risk or this action or things to stay safe. And so for an example, a meeting I gave in December, I was doing a safety share, and it's winter now, or at least supposedly in Utah. We haven't had a lot of snow. But just having the proper safety equipment in your car for winter driving, having snow tires, what are the things you should be aware of and do to be safe when you're driving? Because the reality is as potentially dangerous as mining can be, the most dangerous thing most people are going to face is just the drive to the office.
Sure.
That was the case for working offshore in the oil and gas industry as well. The drive to the dock, to the heliport, the well site was the most dangerous part of the day.
Wow. It sounds like there is no shortage of work with all the different areas that you just described to me that you're touching. How big is your department?
So the IP function for Rio is fairly modest. So Rio has about 60,000 employees globally within the legal department. The IP group specifically has, I think, 18 people or thereabouts globally.
Wow.
And of that 18 people, I think 6 of us are specifically patent attorneys. And then the remainder might be a technology transfer attorney, a privacy, AI, governance attorney, digital rights, those sorts of things. We have a couple of excellent paralegals that help support us. We certainly couldn't do our job without them. We're around the globe, so it's mostly Australia, US, and Canada. It's a global company.
I assume you enjoy what you do. I mean, early on, you started to form your specialty by learning the engineering part of things. You shifted to law, and you found the engineering that you had already worked on to combine the two together and sort of create a niche for yourself. I assume you like it because you've been doing it for a long time.
I do, and I really like where I'm at now because it is less the Groundhog's Day churn of just writing patent applications that I had been doing for a long time without the break of litigation. Being more in an advisory capacity and working closely to align the legal aspect with business interests, more so than I had been able to do in private practice, is a lot more enjoyable. My spouse, she said that since I started at Rio 2 years ago, it's the happiest I've been in a long time. So I think that says something about not just the work, but I feel very fortunate. The people I've been working with at Rio have all been fantastic. First as people themselves, but also just really top shelf attorneys and paralegals.
That's great. So no mutiny coming anytime soon is what you're saying?
No, I don't think so. I sure hope not. You never know what's going to happen, but yeah, it's been a great fit.
Great. That's terrific. So Craig, let's shift it to advice. There are folks out there that want to possibly get into law. And I know you are in a specific law and not a general law, but I'm sure you have some advice for all law, but maybe something for a niche as well.
Yeah, so I would say if you're interested in law, the best thing to do, law school realistically is just a very expensive endeavor. And it is a commitment. And so in something on the order of like at least a third of law school graduates end up not even practicing law 10 years after they've graduated. It puts you in a position you can do a lot of things with it, but it's not something you choose to do lightly. So if you have the opportunity to speak with an attorney that's practicing, particularly if there's a specialty field or area of the law, not even a necessarily a specialty field. Say you're interested in nonprofit law or family law or whatever it might be. If you have an opportunity to speak with an attorney, that's probably the best way to do that. Get a sense, is this something you're going to like? And if you don't know an attorney, you can reach out. Every state has a bar association. And oftentimes there is nonprofit programs within the bar association where attorneys will talk to, are open to speaking with people interested in the law, because it's an often arcane area, and it's one of our goals as attorneys, or it should be, to demystify the area of law for lay people.
That's great advice. Yeah.
If you are interested in law school, think about where you might want to live after graduating, because a lot of law is regional in the sense that firms hire typically from the law schools in their areas. Some big law firms will hire nationally, but those big law firms are typically going to the Yales, the Harvards, the Penns, NYU's, Michigans, and so forth. And one, those schools are expensive. Two, unless you are really committed into that environment, there are great lawyers that went to all sorts of law schools. There is a little bit of a function of law school quality, but it isn't the only thing. I've worked with so many excellent attorneys that have graduated from Brigham Young University, University of Utah, University of Wyoming, University of Denver, a lot of schools out west, and just exceptionally sharp. And these attorneys would do well having gone to any law school, but they've decided, these are the places I want to live, or I don't want to spend hundreds of thousands of dollars for my degree. And one other thing is, even if you're not interested in law school, this is for would be the engineers and scientists. There is a pathway to become what's called a patent agent. The patent agent takes the patent bar, the same patent bar that I took. It doesn't give you a license to practice law per se, but it puts you in a spot where you can draft patent applications, respond to office actions, advise clients to some degree very specifically about that patent application process. So not about like infringement or enforcing the patent. There is a role for that, and especially in very specialized fields. So we see a lot of patent agents in the electronic arts, electrical engineering, where there aren't enough patent attorneys, and also in the life sciences. So we get a lot of PhDs who have particular expertise in drugs, pharmaceuticals, vaccines, things like that. And so it's an alternative path if you're looking for a change from the engineering life to doing something else, or even if you're working for a company, might give you another role in addition to your engineering role or engineering management role, that you would be the in-house person doing some of what I would do, is collecting invention disclosures and then working with outside counsel to obtain and manage that company's portfolio. So it's like an engineering patent manager would be the specific role. So a couple different ways that it might work. And if nothing else, it looks good on a resume. Sure.
So where do you think my degree of going to the Dick Wolf School of Law and Order, where best would I land? In television critic lawyer? If there is such a thing?
Probably. I was just reading something that Dick Wolf did more to harm understanding of police procedure and legal procedure than anybody else in the last 40 years.
Oh, no. So, Craig, any patent work that really makes you proud, something that you've done that you feel really great about doing?
We're working with an internal company called Newton, N-U-T-O-N, and it's really reimagining how to do mining. Mining for millennia is just big rocks out of the ground. The unique thing we're working on with Newton and doing a lot of patenting in the space is it's sort of an intersection of life science and mining. We're using naturally occurring bacteria to more efficiently, on the order of at least 2 times, recover more ore than other methods. And in the process, doing so with less carbon emissions, less water, other inputs. We hope to be more cost effective as a whole, especially as the demand for copper is just skyrocketing. You don't think of using the technology behind, say, insulin production or other life science drugs and medicines intersecting with hauling hundreds of thousands and millions and tons of earth and rock. And how do we apply that in such a way? And it's been a long research path, and we just went to the first commercial scale production with this technology in the world.
Wow.
Just this last fall. And so very excited about that. And it's a testament to the vision and the team of engineers who've been spending so much of their career working on this to put it out in the field.
That's a win for everybody, it sounds like.
Definitely is, especially considering that there's a forecast of a 10% or so shortfall in copper production coming up. So we hope to close that gap with technology like this.
Craig Buschmann, patent attorney, principal IP Counsel USA for Rio Tinto. Thank you so much for joining us and explaining patent law and your whole life.
Thanks. It's my pleasure. And every experience, as you summed up, is a little brick in the foundation of who we are as people. And you never know where that is going to lead us.
You bet. Well, join us again for another episode of Occupations coming soon.
Occupations has been brought to you by lotsofmaps.com. Please follow Occupations the podcast on Facebook, Twitter, and Instagram to find information about our next episode or to see what past episodes are available.